Good morning to all of you. Happy Sunday to all of you. Let us discuss general point. Of course, this is also useful in professional ethics. Madhya Pradesh High Court slaps 4 lakhs. 4 lakhs. It is called fine on a lawyer, Mr. Srivatsava. I will tell his name. Manoj Kumar Srivatsava. For leveling allegations, unnecessarily reckless or vague or vexatious complaints against the judges of Madhya Pradesh High Court. You see, 4 lakhs. Under which provision? This is what we have to know. So please, you can read the case as Inri versus Manoj Kumar Srivastava. This is a clear case of contempt of the court, which is initiated sumoto by the Honorable High Court of Madhya Pradesh. Friends, you all know, according to the Contempt of the Court Act, Contempt of the Courts Act 1971, contempt is of two types. Basically, what is contempt? Contempt is nothing but obstructing the process of the court, not carrying the orders of the court. So, civil contempt and criminal contempt. Civil contempt means whenever a writ is given, if it do not obey, yes. Whenever injunction order is given, if you do not obey, yes, contempt. Whenever any decree is given, if you don't oblige, if you ask the party to get out, then contempt. Criminal contempt, if the high court, if the high court gives some order, if the lower court or if the government officials don't oblige, civil contempt. Criminal contempt is nothing but obstruction of the due process or due process of the court. Suppose if the court is going on and the lawyer uses some foul language or uses or throws chappal on the judge, like that it happened. So they amount to criminal contempt. So if the adjudication process is stalled in any way, like in Madurai bench, the lawyers used to raise slogans against the judges while the trial is going on. Contempt. Right? And important point here, Mr. Manoj Kumar Srivastava, he levelled reckless complaints against judges. Reckless complaints against judges. How did this happen? This is what we have to know. Normally, in the ethics class or bar councils, that is part 4 of the chapter 6, legal ethics and etiquette, rule number 2 will be telling you, have a respectful attitude toward the court. Whoever may be the judge, you must have a respectful attitude towards the court, because you are also a part of the administration of the justice. Lawyer is also an officer of the court, right? But please remember, sometimes it so happens that you lose your temper. Right? Have a respectful attitude toward the court. That does not mean to say that you have to be subservient to this court. Ayya, nee banchanu, dora kalmukta, not necessary. You need not be a subservient servant to the court. You can express your opinion. Suppose in your view, if the judge is not doing correctly or he is not hearing your arguments, if he is not taking things in a right perspective, yes, you can complain to the district authority or the higher authority, like session judge. You can complain, no problem. You can't be a subservient servant. So here, please remember, that means you can file a complaint. But that complaint should not be vexatious, false, frivolous or reckless. The court will treat them. What is a false statement? Suppose for 1 or 2 occasions, definitely they will allow, they will conduct the inquiry, and if they are not satisfied, they will drop action. Or they will refer the matter to the Bar Council, who will conduct inquiry under section 35 of the Advocates Act 1961 and disposal. Maybe suspension or maybe the petition may be closed like that. These things do happen. But please remember, the court can take sumoto contempt action. 1 or 2 occasions they will allow, but if you are going on leveling allegations, if you are going on filing false complaints against the judges, You mean to say, will they keep quiet? Definitely they will take as a contempt, and same thing happened in Madhya Pradesh High Court, and Manoj Kumar Srivatsava was slapped with a fine of 4 lakhs. Because nowadays even the lawyers also, they are not differentiating between the contempt and the comment. No doubt you can comment on the judgment, but you cannot do contemptuous act against the judges. Here also in Andhra Pradesh, lot of contemptuous petitions are being taken. Even the lawyers are also. I think some Kalanidhi or somebody, he was kept in jail for some time. He is not a healthy man. He will be giving, you might see, you have seen him on the video. He is a beautiful orator. He gives very lucid explanation for everything, but he was put in jail because of the contempt action. So you must be very, very careful while dealing with the courts. If contempt action is there, section 12 of the Contempt Act deals with the punishment. Of course, the punishment is 6 months and 2000 rupees fine, but that will be a black mark on your career. You know what happened in Prashant Bhushan case? Yes, Honorable Supreme Court of India, they have imposed a fine of 1 rupee only. But in default, if he doesn't pay 1 rupee, he has to be suspended from the practice for 3 years. He paid, otherwise he would not have paid. So please remember, contempt of court, you have to take it very seriously, and don't resort to the contemptuous acts, and don't become a contemptor. With this advice, I am closing the video. Thank you very much.